Peace to the gods, peace to the gods. Y'all got to forgive me. I'm sitting here trying to figure out, YouTube made some changes, and I'm just sitting here trying to figure them out. Uh, these changes YouTube made, it's ridiculous. I don't know why they would even just go and make a change. It's like, just do some ridiculous type stuff, man. Where's the thing at? Okay, earlier, I was talking about this case. Plains Commerce Bank. The Plains Commerce Bank versus Matthew Beck. Is this it right here? All right. Plains Commerce Bank versus Matthew Beck. Okay. I had to go to another, I had to get another setup. I don't know what happened to my other setup, man. I got to go, I'm just going to buy a whole new fucking live stream setup. I'm so damn tired of, I had to get another setup. I don't know what happened to my other setup. I'm just gonna buy a whole. All right, Eric, that's cool. All right, let me just say this. I'm gonna say this to everybody. I was in a TikTok earlier today, and I go on TikTok periodically, and TikTok to me is like the garbage can of all this information. It's just like a echo chamber of a lot of individuals talking about shit they don't know what the fuck they're talking about. But I usually just lead them to whatever it is. I've been doing this for so long. I'm just at a point where I don't even, try to correct people like that. But I joined a TikTok today. They were in there talking about securitization before we get into some foreclosure talk and a lot of different things like that. And I've been doing foreclosures for a very, very long time. I did foreclosures at the height. I met some of the most intelligent people in the nation. I was all over the country talking to different people, everywhere from Georgia to California to Texas to Ohio. We're talking about foreclosures. And during these times, everybody was trying to figure out some kind of way to defend against foreclosure, all kind of things from, robo signing to, produce the note arguments, rescission of contracts, just a lot of different things, discharging it. That was my thing back then. I was discharging the mortgage. I wasn't the person back in those days doing produce the note arguments. I never engaged in those arguments or anything. Mine was always in approaching it from a discharge of debt type of perspective. But during the course of this conversation, I made a statement. I said a trust does not stop a foreclosure. Now, back in 2010, they were saying the same dumb shit. Almost all the dumb shit they say today, they said back then, because a lot of these guys, they'll go over to Scribd to get their information. They don't get it from case law. They don't read cases. They don't do any of that shit. They just go and listen to each other. Or they'll read a statute, not knowing that a statute is promulgated by the legislature, but to see how that statute is applied in a particular case or the principles behind it, you need to read case law. The problem is, none of them want to read case law. Don't none of these niggas read case law, all right? None of them. I teach my entire class for the last 10 years from case law. About the last 10 years, I've been studying all this. It's been from case law. Hold on. Hey, man, I'm live right now. I'm going to have to hit you back. It's dealing with case law. So I just made a statement. This is just something that I just know, all right, from not only experience, but also as a trust professional. This is something I just know from years of experience in dealing with trust, as well as the fact I teach it for the last 10 years. I mean, really teach it. Not how they do in echo chambers, reading other people's documents and dumb shit like that. Actually teach the subject. So this woman, I guess, she thought, and it's the types, I can't stand the motherfuckers on, especially a lot of the women that be on TikTok, because a lot of them hoes don't like me. And if you're listening, let me tell you this. I don't give a fuck, bitch, if you don't like me. I don't give a fuck about none of you bitches that don't like me on TikTok. One thing you're not going to do is you're not going to prove me wrong. And I go for all you talking about constructor trust. You don't know what the fuck you're talking about either. I'm talking to you hoes too. They don't know what they talking about. It's the blind leading the blind. That's how we in this position in the first place. Because we listening to these white guys, they're coming from the Posse Comitatus, all them dudes coming up from Montana and Washington State, because that's where all this stuff started. Up in Washington State, California, we listen to farmers. These white boys was ignorant. Got y'all going into court saying I'm the real living soul. Think about that shit. So I'm in this chat, right? And I'm listening in it to them talk. And they talk about putting it in they love this word trust. I've never seen a group of people so enamored with the word trust that don't know shit about the subject. Just don't know shit about the subject whatsoever. They just know the word trust. That's all they know. Hold on, let me make sure this is all right, so I got it. So I made the statement that, and this is right here, this is just going to illustrate my point of what's going on TikTok. I said that a trust does not stop a foreclosure. And it's very easy. Number one, you can make no law that will infringe on the obligation of contracts. That's in the Constitution. A mortgage is a contract. There's nothing you can do to infringe on that. Number one. Number two, you can't transfer title you don't possess. You don't possess a allodial title. Just transferring it to the trust doesn't alleviate or eliminate the underlying obligation. Now, any trust professional knows this. But this woman comes to me and says she gonna try to like undermine me in the group and say she got a case to show that where a trust protects from a foreclosure. So immediately I said, well, give me the case. Let me read the case because I'm gonna read it. All I do every Tuesday and Thursday, we read cases. We just read a case last night about the Morris Trust. I'm gonna talk about that in a little bit too, because that's some more dumb shit. I'm just tired of this dumb, idiotic stuff that is being passed around that everybody's regurgitating in echo chambers. They don't read the UCC. They want to deal with negotiable instruments, and then they want to denigrate the UCC. The UCC is the instruction manual for negotiable instruments, Article 3. Don't none of them read it. They don't read it. They just come up with theories. I said, okay, well, where did you get this from? And I'm guilty of, let me just talk about me for a second. Somebody said on the last live, I have plenty of receipts. I got a lot of receipts. I got witnesses, I got receipts. Let me just say that. I don't put a lot of them up front because early on in my career, I was like many of you. I had losses and things like that because I was learning. Because when I started off, I didn't know everything. It took a long time to learn all this shit. So in the beginning, I was doing foreclosures. A lot of the defense, my primary defense on foreclosure was coming in and understanding of what is a real party in interest. And, they had to produce the note arguments. I would ask for a payoff from the bank, and I would satisfy the underlying obligation and then go in court and debate them during, and go into court and challenge them. Back then, there wasn't any social media. So our whole purpose of doing everything we were doing, nobody was doing things to try to one up somebody or prove that they had more knowledge or I got wins. Because all these dudes are doing all that shit because they're trying to sell you some shit. We weren't doing that. It was like you probably had, like 2 or 3 people in your circle. Because, everybody wasn't connected like that. If you got connected, it would probably be at a seminar or some shit like that. But everybody wasn't doing what these guys are doing today on all of the social media, just spreading wrong information. Nobody was thinking in those terms. Nobody was like, well, I'm going to keep my case to show everybody I win so I can show motherfuckers I can charge y'all some money for some shit in the whole webinar. Nobody was thinking like that because it wasn't a social media. So nobody was thinking like, I know I wasn't. I was making money. I was making about $30,000 a month, but that was only for drafting pleadings for people. Drafting their pleadings and their answers in court and things like that. That's what I was doing. That's why I got a lot of experience in filing court paperwork. So I say in the chat that a trust does not protect against a foreclosure, and this woman had to make herself known and tell me, yes, it does. And she said this shit with her chest. She prefaced everything she said by stating that she was a trust professional. I'm here to tell you, you're not even close to being a professional. As a matter of fact, I'll say you don't know shit. And whoever it is that is dealing with you, you're incompetent. And it's too much of that incompetency being demonstrated all throughout TikTok. All right. So she tells me that she has a case that proves that a trust protects in foreclosure. Now, you got over there on TikTok these, I really don't like going to other people's channels because they don't really run their, they don't have a good command of their little group. They're not turn off mics, let people talk, and then they very disrespectful. Like the cat, you want me to be quiet while she talking, but you're gonna let her overtalk me. See, that's some bitch ass shit I cannot stand. I cannot stand a simp, beta male, mangina motherfucker, and you don't like what I'm talking, but nigga, let me tell you something. I got a bigger platform than you. My friend Jamie Foxx, he told me this one time. Jamie, and this is going to be for all you guys out there that you're doing this. All right, take this to heart. Jamie Foxx, we had a conversation. I grew up with him. He's a very good friend of mine from a childhood friend. So I was at his house in California, and we were having a discussion, and I was asking him. He was telling me about everything from Living Color, because, after we graduated from high school, he moved to California and ended up on the show in Living Color. And then from there, his career kind of taken off. So we hadn't caught up in a while. So I hadn't seen him in some years. So when I moved to California, I got an opportunity. We was at a celebrity basketball game. Somebody was questioning whether I knew Jamie Foxx. And I was like, yeah, I know him, blah, blah, blah. And then I guess he didn't believe me. And I started running down our childhood friends and everything. And Jamie Foxx called me like in 5 minutes, told me come to the house. So I took him and my friend to the house, and we have a conversation. And I was asking him, and he was telling me everything that had happened in his career from the time we left and when he left Turl, Texas, and went on to success. And I was asking, he was telling me that in Living Color, that Keenan Ivory Wainings didn't hire Jamie Foxx. Fox did. And he was letting me know some of the particulars behind that. And just to be sure, because it's not my place to put a lot of stuff out in the public, he was just letting me know that it was Keenan Ivory Wainings' show. Let me just put it like that. It was his show. Okay, so when he went on and won this Grammy for Ray, I asked him, did you go and throw that back in their face? And he said, no. He said, you don't do that in Hollywood. He said, you can be up one day and then down the next. He said, you don't ever do that. So that's what a lot of these cats don't understand. They have a celebrity. Yes, I'm a celebrity in this space. I grace you with my presence on your TikTok. You letting a whole bunch of motherfuckers overtalk me that don't know what the fuck they're talking about. I'll never come back to your platform again. I'll never come back to your platform again. You might not care. I don't give a fuck either because all y'all over there talking about a whole bunch of shit you don't know what you're talking about. So she comes and gives me this case and said, this is proof. Now, I asked her to read the case. They don't want to read it because these is people you dealing with that don't read. None of these people read. And if they do read, they don't have comprehension. They don't think grammar is important. They don't think grammar is important. That's why y'all all doing birth certificate authentication. Birth certificate authentication is a result of ignorant motherfuckers who don't know grammar, as well as saying that your status is white, that white and black are statuses. That is a result of ignorant ass niggas who do not know grammar. And I will prove everything that I'm saying. I'm on the warpath. I've already done this about 5 years ago. I took all the videos down because 5 to 6 years ago, I was in this space where I was going to war with everybody because, niggas making videos about me and shit like that, talking shit about me and everything, and I'm firing back at their ass. And I just let that alone because I'm focusing on making money and creating a life for myself. But I'm back in that mode now. I'm back in that, okay, fuck this, because I see people disrespecting me and shit. So I'm back in that motherfucking war mode. I'm waiting. I'm taking out people. I'm taking them. I'm going to take out your business. I'm going to destroy your business. If you are spreading wrong information, I'm telling you, I'm actively pursuing to get you the fuck out of this space. I don't give a fuck if you're a Moor. I don't give a fuck if you some bitch that don't like me on TikTok. I'm here to get rid of your motherfucking ass. Because all y'all doing is spreading wrong information. Listen, let me tell you something. Wins, y'all looking for wins. That right there can let me know you don't know what the fuck you're doing in this space. Most of y'all don't know what the fuck you're doing. Y'all be looking for wins and shit. Public and private don't mix. You can tell these people the simplest principle. You're not going to see evidence of wins on private processes in the public. I told you to read creditors and the bonds. None of you motherfuckers did because it tells you that in there. Let's look at it real quick. Let me see if I can pull this up for you real quick. Let's see if it'll pop up. Creditors and their bonds. Let me go to my SBC University. All right, this is my website, SBC University. Hold on, let me see what I got. Oh, man. All right, this is my website, SBC University. All right, and open this up. All right, and up here, I got a lot of free stuff for you. Okay, so I don't know where did I put that at? Law and Dragon Constitution. Where did I put that? Did I put in criminal? Let me see if I put creditors. I probably put it in here. Creditors. Yeah, there it is right here. All right, creditor. Y'all go over there and download this. All right, this is the first document I ever read in life when I first found out about this information. It's the first thing I ever read. This is how I got my education. So down here, when you read this right here, like right here, do not participate in courtroom drama. Your Honor, will your bond withstand the commercial liability of the charges that are being entered into this day? All right, that's if you have a problem with the judge. And there's a section in here that talks about the attorney. Let me find it. Let me see, where is I think it said, even you are authorized and you are disputing facts, you accept it, blah, blah, blah. Look like they cut it off. I was looking for a part where he told, maybe it's in this section up here. Public defender. Let's see. Please, this is a public show. Okay, right here. You are authorizing the counselor to negotiate settlement for you. Stay out of his way so he can do that. Keep your mouth shut. You are not going to ever testify. Debtors testify. Debtors defend themselves. Debtor dishonor. At some point, the counselor will have to meet privately with the judge to negotiate settlement. The terms might be that the straw man plead guilty. This is for the public show. It is no problem for you to enter a guilty plea to the facts of the defendant. You're not disputing the facts. It may be a problem for the defendant to plead guilty to the charges. Once you have the appearance bond, based upon the issuance of the appearance bond, the lawyer can enter a plea of guilty for the defendant because your exemption is bonding the case. All right? When you accepted and returned the presentment and attached an instrument to discharge all the charges and sent your letter of credit to the public creditor and gave notice of the public that you have accepted the presentment, you became the creditor on the case. The first time you were in court, the lawyer will read the lawyer letter into the record. The lawyer will almost always say he cannot and will not read the letter into the court. He will whine and imply that you are silly and maybe even stupid, but he will read the letter because the judge knows he has it and has been instructed to read it. He knows it because you asked him to file it with the clerk in the file. If he does not have it in the clerk's file before the hearing, you can put it in there on your way to the hearing. Get a certified copy of it to show him when you sit next to him at the defendant's table in the courtroom. Also be prepared to give him cues, blah, blah, blah. Now, there's another part on here that got cut off where he says you need to keep your superior knowledge for yourself. The public is not ready for this. It might be up here, and I might not be reading it. But I would strongly encourage you to read this, but y'all not going to read it. I've already convinced myself of that. I don't know who wrote this document. Whoever wrote it, they have an extremely high level of knowledge. Extremely high level of knowledge. I think it's some judge or somebody in law or something like that, but y'all don't read that. Y'all rather read sovereign citizen material that's floating around on Scrib. That's where most of these guys get their information off Scrib and shit like that because they damn sure ain't getting it from reading case law. All right, so you got to understand a couple of, let me pull this thing back up. All right. So people don't read is my point. They don't read anything. They in echo chambers regurgitating the same shit you've heard for the last 35 years. I'm going to take a lot of videos down off of my YouTube channel because a lot of shit that I said that was wrong. But I'd say about 15%. 85% of the shit I said was correct because I always came out with public and private. I never got on that goddamn right to travel shit because it never was a part of any of the things that I learned in the beginning. Plus, I always had money, so I just wasn't thinking like these guys think. You know, they worried about traffic tickets and shit. But the thing is that they don't read anything. So I'm going to read some stuff for you. I'm going to invite you out to my trust class. If you don't believe that I'm an expert in this subject, just pay the $49 is going to stop. Beginning at the beginning of the year to take my trust class, it's going to be $2,500. I'm going to go on and put the price tag on it because I see like these guys, y'all listening and paying these niggas, and these niggas is trash. Y'all paying these dudes to give y'all trash stuff. Trash. So hell, I might as well get in on it. Y'all want to pay the $49? So she tells me, Plains Commerce Bank Incorporated versus Matthew A. Beck, that this case is evidence that a trust will stop a foreclosure. Now, I want to remind you, I just told you that in the Constitution, this right here should have shut the entire conversation down. You can make no law that will infringe on the obligation of contracts, but they're going to argue with me. There's still, it's more than one way to skin a cat. I say, no, bro, I've done foreclosure defense for 3 years straight. I know all about trust. I know about securitization and all that shit. There's a trust does not stop a foreclosure. They think a trust is some sort of magical entity that does miraculous things. This is what they believe. They think if you get a private trust, you don't have to pay taxes. They think if you get a private trust in some kind of way, your estate has been placed in something that takes it outside the jurisdiction of the United States. It's just a whole bunch of ridiculous shit that they say that I'm like, dude, they don't understand the principles of trust. They don't understand the principles of equity. Nothing. They just say trust and they think they got an indenture agreement, they got something. They don't know anything about the trust merger doctrine. They'll have a trust and they're the only person that's in it. They think that that's a trust. Even though I can show them I can go right here and say trust merger doctrine is a legal principle. Notice we're talking about a principle. They don't know no principles. They don't study principles. They're all into methodology. They're not into principles of law at all. At all. The trust merger doctrine is a legal principle where a trust terminates because the sole trustee and the sole beneficiary become the same person. How many of y'all out there, these grantor trusts that they putting out there, where the beneficiary and the trustee is the same person? And they telling you that you can do that shit. How many of y'all heard this word right here? They will say this word, cesticate trust, as if it's some kind of a trust because they don't know legalese. They haven't even grasped the concept that words in the legal arena have a different meaning than in everyday parlance. But they'll just see that, oh, this is a kind of trust right here. This it's just a beneficiary. If you read case law, the judges still use the word. Well, they don't use it as much today. It's an old kind of an archaic term, but you can read plenty of case law I've read where the judges say, well, the cesticate trust has an entitlement right to receive a distribution from the trust. But they think it's some kind of a trust. And it just lets me know they don't look up the definition of words. Because you see how fast I just Googled this? They won't do this. They're not going to do this. All right. I'm trying to just get back to this. Okay, here it is right here. Okay. So, I was told that this case is proof that a trust can protect against a foreclosure. She said it with her chest. She said she was a trust professional. The guy who was over the damn, letting her talk over me and shit like that. And I'm like, nah, man, you can't do that. Well, let me read the case. They're not going to let you read the case. I'll never go back on that nigga shit. I'll never go back. It's just the stupidity that was on it was just incredible to me. They're talking about securitization. They don't know shit about securitization. I read this case, and within 10 seconds, I knew that it wasn't true. I said, that's not what this is talking about. If you were in my trust class yesterday, we had a discussion about arm's length transactions. This is about well, she started going in and talking about it's a spendthrift trust and all this, and that's impressive to me. Listen, the name of the trust don't mean shit. A spendthrift trust is just a trust for an incompetent. That's a trust fund baby, spendthrift trust. Anytime you hear the word trust fund baby, they're probably a beneficiary of a spendthrift trust. And what the purpose of it is for, like if you have your son and you're a multimillionaire and you see this dude is a fuck up and you're going to die and he's probably going to fuck up all the money, he's going to run through $100 million and blow all of it and shit like that, you make him a party to a spendthrift trust. And you direct the trustees, pay all of his bills, let him go to college, do that,
blah, blah, blah. But you're not giving him control of the money at all. So what was this case about? What this case was about is that the trustee or one of the beneficiaries went and got a loan and tried to utilize trust property as a to collateralize his loan. He have the authority to do that. That's called self-dealing. Now, we had yesterday arm's length transactions and self-dealing in our trust class yesterday. See, that's when you go to a real trust class. You learn things about that. So when you read a case like this, in 2 seconds, you can see that's not what this is talking about. And the reason I have to put her on blast, because she said with her chest, she's a trust professional. Matter of fact, she started out making me believe she was an attorney. Till I called out, I said, your name is doctor. How you a doctor, but you're well, I never said I was an attorney. That's all I needed to hear. Let me tell y'all something. They on Facebook. They on Instagram. They all over the fucking place. They going to come at me, but they going to make a mistake coming at me. See, it takes years to learn this. I don't give a fuck if you don't like. You can use Chat GPT, because my Chat GPT is on fire. You can't fuck with me on that. Not any of this, because I've been doing this for 20 years. I know what to ask Chat GPT. You don't. It takes years to learn these topics. You'll learn this shit on a weekend. It take you about 10 months to become a professional at trust if you study it and go hard at it every day. And you got a good mentor. And the only way to learn it is having a mentor, or you read a lot of case law. That's the only way to learn about private trust. How many of you have heard this right here? This is called the Uniform Trust Code. How many of y'all heard about that? Uniform Trust Code. What is a uniform trust code? It's just they making all the laws uniform. Uniform trust code. Here it is right here. Oh, I guess that didn't pop up. Hold on, let me see if I can get a copy of the uniform trust code. If it'll pop up. Just like you have the uniform commercial code, you have a uniform trust code. But what is the uniform trust code? The uniform trust code is a default provision for all those motherfuckers on TikTok and all those niggas don't know what the fuck they're doing. It's a default provision to handle trust of people who don't know what the fuck they're doing. So I don't even think she read this case. So I'm gonna now I could put this in Chat GPT and let it break it down for you, but I'm gonna read it like I do when I'm like I do in class. I decided to say, you know what? Because Chat GPT making me lazy because it's getting to the point where I don't have to read stuff. I don't have to read through the whole document anymore, but it is a time saver. So they affirmed part and reversed in part. All right, let's look at this. Factual and procedural background. In 1999, Gary Beck and Betty Beck executed a trust agreement creating the B&B Farms Trust. Gary and Betty were the grantors and primary beneficiaries of the trust. Their children, Brian Beck, Jamie Mockley, and Matthew Beck, were named as secondary beneficiaries. Matthew was designated as the trustee. The trust corpus was comprised of the real estate farmland owned by Gary and Betty in Brown County, South Dakota. The real estate was the only asset transferred to the trust. In July 2015, the trust property was appraised at $3.6 million. At the same time the trust was created, Matthew purchased 560 acres of farmland from his parents. This land was sold directly from Gary and Betty to Matthew and never became a part of the trust. Matthew obtained personal financing. Let's pause. Matthew is what? He's also a trustee of the trust. All right? Matthew was designated as the trustee. He has a fiduciary duty. He cannot engage in self-dealing, and every transaction he engages in has to be at arm's length. That means it cannot be for his personal benefit. At the same time the trust was created, Matthew purchased 560 acres of farmland from his parents. This land was sold directly from Gary and Betty to Matthew and never became a part of the trust. Matthew obtained personal financing. Look at the word personal financing. Already we're going into the realm of self-dealing and arm's length already by this. To make this purchase, and Gary and Betty put the proceeds from Matthew's purchase toward paying off a portion of the existing debt on their remaining real estate that was transferred to the trust. In her deposition, Betty described the purpose of the trust as a means to protect Gary and Betty's assets and as a form of estate planning. Okay, nothing wrong with that. The B&B Farms Trust is an irrevocable spendthrift trust. Now, let me say this to you. Calling it an irrevocable spendthrift trust don't mean shit to me. That's just a name. There are a million names of trust. The only real substantive substance of a trust is the indenture agreement, which you have to read to really understand what the trust truly is. The name doesn't tell you anything. You can name a trust whatever the fuck you want. That's one of the principles of trust. You can mold a trust into whatever form you want. It doesn't even have to be called a trust. So right here, the judge, he's trying to take time to educate you. An irrevocable trust is one which may only be terminated under certain circumstances, specifically by judicial action or by written agreement entered into by all the beneficiaries. If continuance of the trust on its existing terms is not necessary to cover out the material purpose, or by judicial action or by written agreement of the trustor and all the beneficiaries, regardless of primary beneficiaries. Now, what does that mean? A trust, the first thing you do when you come to my class is you got to identify what distinguishes a trust from other entities like a corporation, association, or a partnership. Okay? Does it have an economic purpose? I'm talking specifically too right now about trusts that are utilized in commerce. Okay, it has an economic purpose. If it's irrevocable, the only way it can't be revoked. But like it says right here, the only way you can do it, if you put a clause in there, the beneficiaries can revoke it, but it's usually the trustees, the beneficiaries, and the settlor. They all have to agree. What's really interesting is that a revocable trust becomes an irrevocable trust upon the death of the settlor because there's no one alive to revoke it. So after Gary and Betty pass away, the trust will become revocable only with the consent of a majority of the secondary beneficiaries, obviously, because they are passed away. So now we got to get the full consensus of the beneficiaries. Matthew, Brian, Jamie, they are the beneficiaries. These are called the Sestake trusts. That's what another name for them. Matthew, Brian, and Jamie are called Sestake. They are the word means beneficiaries. I know it sounds weird to you, but that's only because you don't know legalese. The trust assets, namely the trust real estate, may be dispersed by being split into thirds to Matthew, Brian, and Jamie. The trust agreement does not authorize the trustee to self-deal or provide for a means for beneficiaries to approve trustees self-dealing. Why did the judge put that in there? A trust expert will read this and understand what they're talking about. A person trying to scam by thinking that, oh, I'm gonna tell you about this case. I'm gonna read the motherfucker. Don't throw a case at me. Matter of fact, I'm gonna read it to my class. Don't ever do that. I already know a trust. I'm not worried about you finding a case because it goes against trust principles. A trust cannot stop a foreclosure. And you should have heard them. They were all trying to come up with there's many ways to do it. I'm like, look, man, I don't need to listen to none of this shit y'all talking about. First of all, you don't respect the fact I've been doing this for 20 years. The record reflects that in 2010, Matthew in his personal capacity. Why does the judge keep talking about in his personal capacity? A judge doesn't say everything a judge comes out of his mouth has a particular purpose. Like, look at this dude right here. He's saying, how do they bring a trust into court? What is the process by which you can and will penetrate a trust? And how is it defended? First of all, if your trust is in court, you don't know what the fuck you're doing already. Because if it's properly administered, it'll never be in court. Every case that you're reading where somebody is in court with a trust, it's a dispute about something. Either the beneficiaries have a problem, they want some sort of accounting. Either the intent of the settler is unclear, so we need to get a declaratory judgment from an equity court. It could be a number of reasons that you end up in court, but it's usually rooted in some sort of dispute that arises. It could be between the beneficiaries and the trustee. That's usually what it is. 9 times out of 10, it's because the beneficiaries and the trustees get into some sort of argument, or because the IRS commissioner done dragged your ass into court for something that related to taxes. It's usually one of those 2 reasons you come into court. See, they talking about defend the trust. Like, how do you defend the trust? Listen, let me explain it to the guy in the chat. When a trust is a right solely enforceable in equity. That's the definition, okay? Meaning, now concentrate on the word equity. So you can only go into an equitable court, okay? When you go into court, the judge does, contract makes the law. The judge is going to read the indenture agreement first, and then he's going to read the trust minutes to see if the trustees did everything that the indenture agreement said they were supposed to do. Trust require record keeping. If you don't have minutes or records, you can't defend shit with a trust. Minutes are the lifeblood of a trust. Okay, so it goes on. Let's read this right quick. Down in the, he's talking about, I like reading the footers and everything because they got some good information in there. Wait a minute, let me go back up here though. Okay, first, let me finish reading this. After Gary Betty passed away, the trust will become revocable only with the consent of the majority of the secondary beneficiaries, the Sesticade Trust, Matthew, Brian, and Jamie. The trust assets, namely the trust real estate, or the corpus of the trust, or the trust raise, may then be dispersed by being split into thirds. Notice we have the word dispersed. All right, this is usually happening at the termination of the trust, or if there are specific provisions in the trust that allow for this. But all trusts have a termination date. This is the one feature that distinguishes it from a corporation. Corporations have a perpetuity. They live forever. Trust can be renewed. The trust agreement does not authorize the trust to self-deal or provide for a means of beneficiaries to prove self-dealing. This is the reason right here. It had nothing to do with the property in the trust. It had everything to do that he was not authorized to go get a loan and use the trust property in the trust to collateralize it. And the banks should have known that. That's why they couldn't foreclose on his loan. This is the type of shit that they do. Let me tell you something. When y'all don't read these cases, they come and tell you anything. I'm going to show you next the Moore Science Temple. The Moore Science Temple of America, look, bruh, I'm here to help you. I understand what the Moore Science Temple is dealing with. You're dealing with a lot of these fringe Moors who are not a part of the official Moore Science Temple of America. I know what had happened, how they all start breaking off, and they all over the place. These motherfuckers run around talking about if you claim your nationality and all this shit, and this is our land and all that shit. I'm going to show y'all where all that came from. I'm going to bust up. I'm not busting up the Moore Science Temple of America. They are not a part of this at all. The Moore Science Temple of America, I got your back, bruh. I got your back. I'm going to help y'all get rid of all these leeches running around here fronting and shit like they're part of the Moore Science Temple of America. I got your back. I'm going to read them the Frank L. Bay case right here. I used to have it up 5 years ago. I took it down but no, fuck it. I had to figure out, I'm like, no, me and the Moore Science Temple on the same side. It's these motherfucking fringe niggas that is the problem. The record reflects that in 2010, Matthew, in his personal capacity, notice he keeps saying personal capacity, and the trustee of B&B Farms Trust obtained 2 loans from Legendary Loan Link Incorporated. He obtained $564,000 loan on August 16, 2010, and a $1,225,000 loan on September 16, 2010. He got their ass. Oh my God, he got their motherfucking ass for $2 million. That nigga got their ass. When was this? In 2010. Somebody got fired at the bank. This is a good case, though. I like this case. This is a good case. It's a good case. Matthew executed mortgages on the 680 acres of property constituting the trust property and 560 acres he owned personally to secure these loans. Remember, back here, the trust agreement does not authorize the trustee to self-deal or provide a means for the beneficiaries to approve self-dealing. Anyway, in an irrevocable trust, a beneficiary can't tell a trustee nothing anyway. But he didn't went out. These people, the settler, put property in trust, and he went as a trustee to go try to get a loan and use the property in the trust to collateralize it, and he don't have the authority to do that. That's called self-dealing, which is, if you're a trust professional, it's one of the first things you learn in the first week of teaching this subject. How are you a professional and read this and don't know that? When she said it, when she gave me the case, I said, let me get it. I tried to read it. These motherfuckers wouldn't let me read it. They talking over each other. Do I say, motherfucker, read the case? They don't want to. Because let me tell you what happens. When you read the case, you expose them. First thing you expose is their comprehension. Do they comprehend what they're reading? 90% of them don't even comprehend what they're reading. That's what these attorneys are talking about out here. Y'all listening to a lot of crazy, y'all listening to people in high school. These niggas wasn't even good school students in high school. They don't believe in I heard a nigga tell me that the word citizen capitalized in smaller case, it don't mean nothing. I'm like, dude, you don't know the difference between a proper noun and a common noun? They don't know. They don't give a fuck. They don't think it means shit. Even though law is a science and everything, which means that every word, every syllable has a specific, definite meaning and purpose. If you're not approaching it like that, you don't know what the fuck you're doing. The record reflects that in 2010, Matthew, in his personal capacity as trustee of the B&B Farms Trust, obtained 2 loans from Legendary Loan Link Incorporated. He obtained a $564,000 loan on August 16, 2010, and a $1,225,000 loan on September 16, 2010. Matthew executed mortgages on the 680 acres of property constituting the trust property and the 560 acres he owned personally to secure these loans. So he took his personal property and trust property and went and got loans. A trustee is no different than your government officials. Every time the government does something, there has to be a statute that says they can do it. Same thing with a trustee. Any action that a trustee takes, it has to be in the indenture agreement. He says he can do it. That's when you go to court, the first thing the judge is going to do, he's going to read your indenture agreement. The next thing he's going to do, he's going to look at the record of the actions that the trustee took, which is usually in the trust minutes. So that's why this judge, in this case, he read the instructions to the trustee. He went through it to see what powers were delegated to the trustee. There were no powers delegated to the trustee to self-deal or to go take out personal loans or anything like that. That's how it defended it. It wasn't because you put the property in a trust. It was because he didn't have the authority to do that. That's what this case turned on. Let's look at it real quick. I'm going to pull up my chat GPT. Is this it? Let me go in that new chat. All right, cool. All right, so let me see. Did I download this? Let me download this real quick. I'm going to do this real quick for you because I got a class tonight that I got to go teach, a status correction class. And I've made a whole bunch of changes to that too. Oh my God, it's so much new information that y'all. All right, so let me, what is that? My documents. So let me pull up Chat GPT. Let me put it on the screen so y'all can see it. Okay, move it out the box. Okay, so I'm gonna upload this case to my Chat GPT. Where is it at? Let me see. Where did I just put it? I just put it somewhere. No, I put it there. Hold on, am I wrong? No, that ain't it. I'm just. Oh, that's Indeed. No wonder. Documents. Okay, there it goes. All right. Here it is right here. All right. Okay, now I'm about to talk to my Chat GPT. Allow. Okay. How you doing? Okay. I'm live on YouTube right now, and there are people watching. And we were talking earlier. I got cut off earlier on the internet, so I'm back. But remember, we were talking about Plains Commerce Bank Incorporated versus Matthew Beck. And I want you to break down the points of exactly what this case is talking about, because I was told that this case demonstrates that a trust can protect against a foreclosure. What say you? You're going to read the document. All right, I'm good. And this is a great case to break down live because it's being misused online. I'm going to be very direct and very precise so your audience understands this cleanly. Short answer for your viewers, no. Plains Commerce Bank and Beck does not stand for the proposition that putting property in a trust stops foreclosure. That claim is incorrect. What this case actually stands for is this: a lender cannot foreclose on trust property when the mortgage itself is void because the trustee lacked authority to encumber the trust due to self-dealing and spendthrift clause. Now, that's the reason. Now, I read it first for you because these motherfuckers will try to act like I'm using Chat GPT for information when I told them right there in the damn thing. I said, no, that's not right. I knew that in 2 seconds. But this is a trust professional, and these who y'all listen to all over social media. Y'all listen to a whole bunch of lazy motherfuckers who don't do any type. It take about 10 months to learn trust. They got, this dude's in there talking about they got students. I said, you got students? He started talking about the UCC. You don't know that the UCC is for personal property? They don't know what the UCC is for. They in there talking about negotiable instruments. Nobody even read the law merchant. This is what they don't understand. This is about the law merchant. When you talk about UCC, all it is a codification of the law merchant. Every country on planet Earth has done it. They don't call it the UCC in every country, but every country has to have it because every country on Earth is bankrupt and they're using negotiable instruments. So everybody on planet Earth has to follow the law merchant. And our country, it was adopted in all 50 states. Louisiana was the last state to adopt it. Okay, it was adopted because we all have to have a uniform way of doing business on planet Earth since everybody's using debt instruments. For somebody to denounce the UCC, they are damn, I don't even listen to nothing else they got to say. I said, Nick, you don't know what you're doing. They don't know what a holder in due course is. They don't know what a holder is. They don't know what a claim and recoupment is. They don't know what a claims to an instrument is. Nothing like, nobody talks about law or anything. They in echo chambers just bouncing bullshit off of each other. I agree. Thank you for shepherdizing your teachings, brother. That's what I like to hear. See, that's what I like to see. See what CFC 444, he said, I still shepherdize everything. You got to make sure it's still good law. You can't learn trust no other way than through reading cases. Not private trust. You might can do something on statutory side, but we're dealing with private trust. You're not learning private trust. There's not a lot of formal books written on formal trust. That's why Gwen Wyckoff wrote that book. There's only a couple of documents that I know of that you can read on it. Passing Bucks, Weiss Concise Trustee Handbook, and all the shit I got that I'm not going to let circulate around the internet. Or you can get the American Jurisprudence on Business Trust. That's good too. It ain't a lot of motherfucking material you can go to learn this subject. The public and private don't mix. They ain't in the public writing books for teaching y'all how to operate a private trust. I like the other brother too. He said, I bought a style and grammar book and it specifically reaffirms the difference of proper and common noun in law. Listen, man, I appreciate that. That's the first thing I did. Listen, let me tell you something, y'all. I was very good in school. When I was in college, I was on the dean's list, okay? I dropped out because to have my own business because I never saw myself working for anyone. As one day the instructor told me, he said, your employers are going to, as soon as he said, your employers are going to be looking for this, I was like, I don't know what came over me. I said, did this man just say my employers? And I was like, nah. They don't understand that you can't be solving a private working a job. They don't understand that the tax laws are designed for businesses, not this is what they mean, own nothing, control everything. They don't get it. They don't understand the game, how the game is being played. Let me tell y'all something. Stay away from these anti-government and the tax protesters. They are some of the most illiterate and ignorant and dangerous people in this space. Most of the tax protesters are them white people that come up that I don't want to denigrate them or anything like that, but they are ignorant group of people. These are not the elite white people who talk like that. Elite white people are not tax protesters. They don't understand the purpose of taxes or what mitigating your tax exposure means. The only way to really understand taxes and the mitigation of it at a high level is understanding trust. They go hand in hand. You're going to learn taxes as you learn private trust. They go hand in hand. The spendthrift clause explicitly prohibited beneficiaries from encumbering trust property, trust assets being liable for beneficiaries' personal debts. The trustee was also a beneficiary, red flag. That's a red flag because, you got the trust merger doctrine. Even though a trustee can be a trustee and a beneficiary, that is allowed, but it's a red flag. Seeking a personal loan, this creates an automatic fiduciary conflict. The trust law treats this as presumptively invalid because the trust expressly authorizes self-dealing or the transaction strictly complies with statutory exceptions. This trustee did neither. The loan was not a trust debt. The Plains Commerce loan was signed by, that's why they couldn't foreclose on it because it wasn't the debt of the trust. But They gonna put, and now they using this. It's being used all over the internet. I'm glad. I don't even know why they put it in my face. I don't even know what possessed her to fuck with me like that. Why would you fuck with me? I know y'all don't like me, but I'm the wrong nigga to fuck with. Don't fuck with me. I don't give a fuck if you're a woman or a man. I damn sure don't like feminists. And I have low tolerance for ignorance. When you see me come in, you better do what some of them did and get the fuck out of there. Because my purpose is to shut down all the bullshit. Do y'all see this right here? This is what I am trying to stop. Sovereign said, look at this shit. Look at it. I just want y'all to look at this. Look, just look at all these cases. Just cases, 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 90% of the people who are going in there, it's a clown show. Look at this. Look at this. Look at this. I could just do reviews and I could just start just doing reviews of cases. Don't have to do shit. As a matter of fact, that's what I think I'm gonna start doing. Sovereign citizen can't stop talking. Sovereign citizen can't stop losing after L after L. Judge went viral. Judge laughs at sovereign citizen. I'm above the law. Dismiss my fucking case. How to ruin your life in 5 minutes. Ruthless judge obliterates sovereign citizen clowns in court. Sovereign citizen fraud case dismissed. Sovereign citizen judge laughs at sovereign citizen. And these right here, I think these is COINTELOPRATIV because whenever I see the same judge, I was like, how the same judge can get the sovereign citizen? So I don't give them any credence or anything like that. And sometimes I can review a case and the guy does have a point in what he's saying. But a lot of times it's not. They just in there regurgitating the script they heard somebody else tell them to say. They don't even understand what they're saying themselves. Maybe I'm a little liable for that as well. You know, let me switch gears real quick. I got another thing I want to talk about. I'm gonna get on these Moors now, and let me preface what I'm gonna say. This is not an attack. Well, obviously, when I read the case, y'all gonna obviously see it's not an attack against the Moor Science Temple of America. I just want to let the Moor Science Temple of America know, I got your back. I got your back. I understand what happened. I do think you got infiltrated. Something like that. I think it was an infiltration that occurred in the Moor Science Temple of America, and I'm going to show you why. All right? So when we go to Google, call all the Moors too. I want y'all to call every fucking Moor you know and bring them to this channel because you know that first thing will come out their mouth is if they calling me a dirty Moor, I already know they're not a part of the Moor Science Temple of America and they don't know what the fuck they're talking about, so I don't respect them anyway. So they then started this thing where they think they can operate outside the bounds of the official Moor Science Temple of America. So let me get this right quick. So if we go to Google Scholar, I did this last night in my class, and my class just tripped out. It was like, because they make a mistake they don't understand. You got to remember, I've been doing this 20 years. I've been doing it 20 years. I know where everything y'all talking about came from. I know the reason why y'all split the splinter groups. I actually made this video 5 years ago. I took it down to prevent myself from, because a lot of the Moors with Fezes, they started making videos about me. He's a dirty Moor, blah, blah, blah. He talking shit about me. I could have went in on him, but I'm like, I said, that's the organization. Fuck it. I don't have anything to do with that. But I'm so fucking sick and tired of these motherfuckers coming to me talking about nationality is the order of the day. Have you claimed your nationality? You claim your nationality. You don't have to have it. You can't put no civil and criminal charge. Oh, this old dumbass. This is the biggest one is this is our land. I'm going to show you where this is our land came from. Why they are out. They're saying they are operating on our land. That's what I'm about to show you. So we go to Google Scholar. And we go to case law. And we're going to go to Frank L. Bay versus Moorish Science Temple of America. This is, I want y'all to send this out. This is where they got it. This is where it all started. I'm going to educate the Moors out there because y'all, I've been doing this 20 years. I done gave you a pass. I'm not giving none of you motherfuckers a pass anymore. This is why they're out there saying it's our land. Y'all operate on it. The Moorish Science Temple ain't said none of that shit. It started when they would start talking about that they got a trust. Y'all heard them say that? How many people in the comment section have heard the Moors talking about the Moorish Trust? How many of y'all have been hearing them talk about that? Put a 1 in the chat if you have heard them talking about that they have a trust that Noble Drew Ali created for them and that the land was put into the trust. How many of you know about that? Don't be afraid. Tell the truth. How many of you been hearing? I know y'all done heard it. How many of y'all heard that? I'm going to wait in the chat. How many of y'all heard? Okay, thank you. All right. I'm going to show you where it came from. And this is the lesson. I hope I'm going to try to make sure they get a lesson. Don't fuck with me. And I know it sounds arrogant, but it's not that really, brother. I don't have anything against nobody. But y'all keep coming in my face, acting like you know something I don't know. I know more than you. I'm sparing you. You're not sparing me. I'm not sparing your ass no more. I'm not sparing none of you motherfuckers no more. You piss me the fuck off. I'm on the war path. All right, let's read this real quick. You're going to put some motherfucking respect on my name. I'm going to do a baby on y'all motherfucking ass. All right, so here's the case that jumped off all the shit that y'all are seeing, these Moors talk. It's only a small section of them. This is not the, see, you can see right here. This is Frank Lewis Bay. This is the split. There's a split that happened in the Moorish Science Temple of America. You got this fringe group that's led by this guy, Frank Lewis L. Bay. And then you have the official Moorish Science Temple of America. This entire case turns on whether or not there was a trust. Now, this guy, Frank Lewis Bay, won the case. He won. But he only won because the Moorish Science Temple did not identify an injury. It wasn't because there's a real trust, and I'm going to show you. But he went back to all his members and made all of them believe that. And I'm going to show you that too. And they do this because they know none of y'all read cases. On March 27, 1997, the Circuit Court of Prince George County, George County issued an interlocutory injunction restraining Frank Lewis L. Bay. Now, I'm gonna go past all of that, and I'm gonna start right here. This turned on the fact, I'm gonna try to put it in a summary. This guy, Frank L. Bay, just appeared out of nowhere. They got 300 and something temples from the Moorish Science Temple. Ain't nobody even heard of this motherfucker. He popped out of nowhere saying that Noble Drew Ali created a trust and appointed him as the trustee. Now, Noble Drew Ali died in 1929. Let me go down here in the case. This right here. This is the shit they do. Right down here in the bottom, it's a transcript from the case. It says, during the December 17th, 1998 trial discussed infra above, the circuit court asked petitioner whether he could document his appointment as the trustee of the temple. The following testimony ensued the court. And the trust documents were presented to you when? In 1978. By whom? By Moore. They asked this nigga who gave him the trust document. He said by Moore. This who they following. This who they following. They supposed to be intelligent. They want me to participate in this. He said by Moore. By who? A Moore. A Moore named Lars Rossi, phonetic, gave me the actual deed of conveyance that culminated my appointment as a trustee. Now, you know they always start using this goddamn language to start trying to sound intelligent. Culminated, you know, a deed of conveyance is sale. He said, you were appointed trustee in 1978? No, I received the documents, the Holy Quran, portions of which the petitioner later had read into the evidence, Your Honor, in 1978. When were you appointed trustee? When I obtained knowledge of the trust, Your Honor. When were you appointed and who appointed you? In 1978, I received the court. When were you appointed? Well, first of all, who appointed you trustee and when were you appointed? My appointment, Your Honor, as I said, my appointment was a legal appointment in 1928 under Illinois law. What the fuck does that mean? They start talking this shit like, anybody ever seen like Living Color? They start talking about, you know, the culmination of the trust and the cestacea when I injected into the corpus of the trust, and then, you know, the securitization that occurs afterwards, you know, then the injection of these of the trustee when he comes, and the disbursement that comes from the trust is a byproduct of the culmination of my appointment as trustee in 1970. Like, what the fuck are you talking about? Petitioner, my appointment, Your Honor, as I said, my appointment was a legal appointment. I don't know what the fuck a legal appointment is when we talk about trust. A legal appointment? A trust is usually an agreement between the settlor and the trustee. And the trustee has to accept it. In 1928, he said, Your Honor, as I said, my appointment was a legal appointment in 1928 under Illinois law. What the fuck? Petitioner, I received my appointment directly from the Prophet Noble Drew Ali according to the requirements of Illinois in the appointment of trustee to represent an express trust estate. So you received the appointment directly from the Prophet Noble Drew Ali, who was dead long before you were born? Is that what you're saying? That is what I'm saying, Your Honor. In later testimony, petitioner refined his testimony regarding his appointment, acknowledging that no, it's not a legal appointment and so forth, but it's a proper appointment. Now, I had the preference when I'm going to read, because I want you to see anybody who doesn't know trust law will look at this and think there's some substance to it. This is a clown show. This is a fucking clown show. All right, let's continue. Let's go read the case now. All right. A background and organization of the Moorish Science Temple of America Incorporated. Noble Drew Ali founded the Moorish Holy Temple of Science in 1913 in Newark, New Jersey, as a vehicle to advance the tenets of the Islamic faith, as he viewed them to be, in the United States. He subsequently incorporated the temple in 1928 under Illinois law as a civic corporation. They got all of the original documents that Noble Drew Ali had to form the Science Temple of America, placed in evidence on this case. The sheikhs of the temples brought it and put it into evidence. So in this court, they're looking at the original documents that Noble Drew Ali utilized to form the Moorish Science Temple of America, and ain't shit in this motherfucker talking about a trust. Let's look at it. In 1928, Noble Drew Ali changed the name of the corporation to the Moorish Science Temple of America Incorporated, and changed the purpose of the organization from civic to religious. It's a religious corporation. During his leadership of the temple, Noble Drew Ali served as the moderator, the head of the temple, and also was referred to as the prophet, a title of religious but not legal significance within the corporation. Let me say this about, this is where the mainstream Islam is going to separate from them, because the word prophet is usually ascribed to someone who brought a book. Like Jesus is called seven prophets, and Muhammad, the prophet Muhammad, was the seal of the prophets when he brought the Quran. Okay, so each of them brought a book. Like Moses, he's one of the prophets. He brought the Torah. Jesus brought the Injil, which is the book of Revelations. That's his book. It starts out, this is the revelation of Jesus Christ, which God gave unto his servants, which God gave him to give unto his servants and show them what's surely come to pass. That's Jesus' book. So Jesus in Islam is referred to as a prophet, and the Christians don't like that, but in Islam he's referred to as a prophet, one of the seven prophets, and Muhammad being the seal of the prophets. So they come with this term prophet, and he's presented a book that, by the way, if everybody, and they're going to get mad at me for saying this, you have Levi, it's called the Aquarian Gospels by Pastor Levi, and this is what's really funny to me, how they talk about white people, but this pastor is where they took the Quran Circle 7 from. And they can't deny it, because you can read this book in the Quran Circle 7. You can see it's plagiarized from it. So they won't deny it. However, that's neither here or there, because that's not important to me. What's important to me is the truth gets out, because the Quran Circle 7 has a lot of truth in it. In no kind of way does this diminish, in my eyes, the importance of the Quran Circle 7. I really think it's a beautiful book, but the substance of it was taken from a white man. All right, so let's continue with this case, reading this case. All right, so according to the temple's Articles of Incorporation, as well as its constitution and bylaws adopted in 1928, the elected officers who served under the moderator included the branch sheikh, the grand sheikh, and other chairpersons. The temple's outposts grew rapidly under Noble Drew Ali's leadership, with temples established in many states. Noble Drew Ali died in 1929 during the temple's 7th annual national convention in September of 1934. It adopted rules and regulations regarding the governance and succession of officers of the temple. Under these rules, the moderator's position became an elected one known as the Supreme Grand Advisor and Moderator, which continues to be the title used by successive national corporate leaders, including the current one, Robert Love Ale. I love the fact that he used Ale and not Bay. A resident of Prince George's County, Maryland. Other elected officers are known as Grand Governors or Governesses, Grand National, and Assistant Grand National Secretary, Grand National, Assistant Grand National, Treasurer, Secretary, Treasurer of the related Moorish Manufacturing Company. Now, remember, judges don't say anything for no reason. What he's identifying is a corporate structure that it doesn't have anything to do with a trust. Anybody who is a professional in trust understands there is a distinction between a corporation and a trust. That's one of the first things you learn. So the judge is purposely right now showing you Noble Drew Ali formed a corporation under Illinois law. As a matter of fact, he took right out of, it's the Religious Incorporation Act. Wait a minute. Illinois. I almost forgot. Illinois. Let me say right here. This is what Noble Drew Ali formed the Moorish Science Temple of America under. As a matter of fact, if you look at some of his documentation for entry into the temple, they take language straight out of this. In any case where a church, congregation, or society formed for the purpose of religious worship has filed or causes to be filed prior to the effective date of this act, an affidavit in the office, wait a minute, let me see if this is it. Religious corporation, no, that's the Validation Act. That's not it. Hold on. That's the validation. Where is that Religious Incorporation Act? Is this right here? Maybe this is it. See, this is why they got the exemption from taxation. They are exempt from taxation, but not for what reason they telling y'all. Let me get back over here. I don't want to digress too far. I'll come back to that. All right, so Noble Drew Ali died. Here are all the officers of the Moorish Science Temple of America. The dispute. On the 10th of September 1996, petitioner provided to all governors, grand sheikhs, and head office officials of all temples of America affiliated with responded a memorandum announcing that he was appointed as trustee of the express trust created by the Prophet Noble Drew Ali. Through fulfillment of that appointment, I've invested with all authority and power the Moorish Science Temple of America. Accordingly, my office as chief executive officer of the temple is effective immediately. I will appoint by January 8th, 1997, an executive council, rulers of which I will act as chairman. This nigga just came out of nowhere and just usurped their authority. And this is what started. This is what all these Moors out here following this guy, or they don't know that they are. Well, first of all, the claim on the land, the Moorish Science Temple of America didn't make those claims. These are the fringe groups making the claims to the land. That's not the Moorish Science Temple of America, at least not I'm aware of. I'm not a part of their organization, so I may be wrong in saying that. But I'm reading this case, and from my research, it's this Frank L. Bay personage that started all of this shit. He's the beginning of all of this. So it goes on, it says, petitioner also stated that a similar memorandum will be prepared and circulated among all members of the temple. He concluded his announcement by advising the temple leadership to seek out the aid of an attorney regarding petitioner's legal rights as the temple's trustee. On the 22nd of January, 1997, respondent petitioned the Circuit Court of the Prince George's County to issue an ex parte interlocutory and permanent injunctive release against petitioner to prohibit him from referring to himself as an officer, director, agent, or trustee of the temple. Moorish Science Temple came at him. Like, nigga, who are you? This nigga came out of nowhere. I want y'all to think, was the Moorish Science Temple infiltrated? That has been the rumor. Responded in his complaint alleged that petitioner fraudulently was collecting money in the temple's name, disseminating false and misleading information about his status as a trustee of the corporation. How the fuck you be a trustee of a corporation? I'm telling y'all, it's a clown show. And attempting to recruit temple members. This conduct, it argued, would embarrass and tarnish respondents' reputation and good name. That's the Moorish Science Temple. On the 24th of January, 1997, the Circuit Court ordered petitioner, a resident of the District of Columbia, to show cause at a hearing to be held on the 7th of March, 1997. Why a temporary restraining order should not issue as requested. Petitioner did not attend the hearing. Frank L. Bay just ignored the shit. And the reason he ignored it, because he felt like that the state couldn't get involved in a religious dispute, which he was partially right on. Frank L. Bay, let me say this about Frank L. Bay. I don't know who he is, but he had good counsel. He had some good counsel. And I'm going to show you why. Because he won this case, but not for the reasons that he's telling all his followers. The court ordered on 26th of March 1997 that respondent be granted the interlocutory injunction restraining petitioner from referring to himself as an officer, director, agent of, or trustee of the temple. In response to this order, petitioner, after it was served upon him, filed a motion on the 25th of April 1997 to dissolve the interlocutory injunction and requested a hearing. On the 27th of June 1997, he filed a counterclaim in which he sought to take possession of all temple trust property and assets. In an amended counterclaim filed on the 4th of August 1997, petitioner also asked the court to grant an injunction restraining the temple from relying on the 1934 bylaws and Love Ale from representing himself as the president of the temple. The parties tried the matter before the circuit court on the 17th of December 1998. In support of its request for permanent injunctive relief, respondent stressed several points advanced previously in support of the temporary injunction. First, it argued that petitioner had no authority over or within the organization in which he was neither a member nor an elected officer. Specifically, Love Ale testified that only the Supreme Grand Advisor and moderator is authorized under its charter and bylaws to appoint a sheikh, and that neither he nor any prior Supreme Grand Advisor had appointed petitioner to that or any position within the temple. Okay, they don't know who this dude is. He don't have no authority whatsoever. Second, Love Ale testified the temple does not recognize or utilize the title trustee. This is what the Moorish Science Temple of America has said. We don't have a trust. It's not in any of y'all corporate documents. That's why this fool brought a copy of the Quran Circle 7 and said this is what created a trust. He called it an express trust too. His members, they don't know. I'm going to show you. Instead of calling them trustees, he called them sheikhs and sheikhs. Third, respondent concluded that petitioner's conduct would hurt both the temple's reputation and its purse strings. The temple, through Love Ale and counsel, acknowledged, however, that its officers had not witnessed petitioner soliciting members and that it was unable to provide any evidence the petitioner had collected any monies under the guise of being a trustee of the temple. Now, I don't know why he said that. Maybe that was pride, but that right there is one of the points why they lost. He's like, okay, when you go to court, you have to identify an injury. So the court is asking, okay, he's doing all this. How is that injuring you? Well, he's collecting money. Have you seen him collecting money? Well, no. Okay, that's point one. They lost. The Moorish Science Temple of America lost on that point. Let's go to the next one. Defending his claim of control over the temple, petitioner countered that Noble Drew Ali created in him an express trust for the temple and its holdings. Now, Noble Drew Ali died in 1929 before he was ever born. I want somebody out there. I'm going to pause for a second. Any of you people out there who don't like me, I know it's a lot of you don't. Would you please explain to me how that's possible? I'm not being mean. I'm not trying to be mean. I just want to know, how is it possible for you to be a Okay, I'm back, y'all. I apologize about that. I had a little problem. Okay, now, right here in this, defending his claim of control over the temple, petitioner counted that Noble Drew Ali created in him an express trust for the temple and its holdings, and that his trust dated back to the 1928 incorporation of the temple. I have no idea how in the fuck they got something in the footnote right down here. 6. In response to one of the circuit court's requests for documentation of the trust, which petitioner asserted he was given, petitioner replied, okay, this is when the judge asked him, okay, so you were appointed as a trustee, so do you have some trust documents or something like this? So this is what Frank L. Bay told them. Your Honor, we are coming up with here is an express trust that was created by Noble Drew Ali in 1928 according to Illinois law. What? That's all I could come up. That's all I could come up. I'm here as trustee. I come to present the evidence, the temple's Holy Quran and the temple articles of incorporation before the court to establish that a trust was created by Noble Drew Ali in 1928. Upon the request of petitioner, the court then read into evidence portions of the temple's articles of incorporation and passages from the temple's Holy Quran. According to the petitioner, these documents were evidence that the trustor is Noble Drew Ali. I am the trustee. Because petitioner was not born until much later, he obviously was not identified by name or otherwise in these 1928 documents. Okay, so he just read the incorporation papers and parts of the Quran and said that an express trust was created. This is nigga shit. This is nigga shit. He said that I want to reiterate, this started a whole movement, just like birth certificate authentication. I can't shut that shit down for nothing. It started a whole movement. You can't shut it down. I make videos showing where it came from, Minnesota Rules of Practice 220, everything. They ain't listening. It's the same thing with this. It took off like fire. You can't shut it down. They talking about this is our land. They operate, they doing business on our land. All this right here, they doing this, and this is where it originated. Let me go back. Defending his claim of control over the temple, petitioner counted that Noble Drew Ali created in him, Noble Drew Ali created. Now, he's not even alive yet, but somehow, some way, Noble Drew Ali created in him an express trust for the temple and its holdings. This motherfucker sound like he on drugs. And that this trust dated back into the 1928 incorporation of the temple. Petitioner explained that he became aware of his appointment in 1978. That's how they talk. I became aware of my appointment. You became aware of your appointment. How? You wasn't alive. Petitioner explained that he became aware of his appointment in 1978 when Amor, I don't know who this is, gave him a deed of conveyance to the temple and that he accepted his appointment in 1981. So he said Noble Drew Ali died in 1929 and he accepted the appointment in 1981. To support his contention, petitioner asked the court to read into the record several documents that claimed evidence his expressed trust, including portions of the temple's Holy Quran, which he claimed traced the title of various lands, including the entire United States from ancient peoples to the Moorish Americans of today. The title traced in the Quran, he argued, is the legal instrument which made him the rightful trustee of the temple. Petitioner then argued that Love L's presidency and the offices held by other temple members are invalid because they were not elected by the grand body. They were elected by the grand body, but not appointed by the prophet. In response to the temple's claims that he was Let me stop. All right, I got game my composure, man. I just can't believe this shit, man. It's hard for me to believe. This is what's going on inside TikTok, all this type of shit right here. I'm trying to tell you. I read this 10 years ago. I've already read this about 10 years ago. I've been doing all this for 10 years. I have not said nothing. I just let them come in my face. This our land. You don't know what you're talking about. Blah, blah, blah. That's all right. And I leave it be. But they piss me off. I'm not pulling no punches no more. All right. To support his contention, petitioner asked the court, okay, we already did that. In response to the temple's claims that he was conducting himself in a fraudulent manner, petitioner responded that he could not have committed fraud or usurped Love L's presidency since Love L was not authorized the leader of the temple. Namely, not appointed by the prophet or petitioner. He also argued that he had not fraudulently recruited members or collected a substantial sum of money. Rather, petitioner claimed that that as the appointed trustee of the temple, he had the right to take possession of all trust property and assets into his immediate physical custody and possession. This is called usurpation. Judgment of the circuit court. So let's see what the court said. Let's see what the court said. Are y'all riding with me? Put a 1 in the chat if y'all still riding with me. Put a 1 in the chat if you. I am exposing dirty Moors. These are your real dirty Moors. Once again, this has nothing to do with the Moorish Science Temple of America. Nothing to do with you. All right. Judgment of the circuit court and court of special appeals. After considering the evidence, and this is how you're going to know who the dirty Moors are, because the ones that get mad at me, that's how you're going to know they're a dirty Moor. Because the people in the Moorish Science Temple of America, they're not going to be mad at me for showing y'all this. I have friends in the Moorish Science Temple of America. Very noble individuals. And very intelligent. After considering the evidence, such as it was, and the parties' arguments and counter-arguments, the circuit court granted the temple equitable relief and ordered a permanent injunction against petitioner on the 6th of January, 1998. Although petitioner had insisted repeatedly that he had been named the trustee of the temple, the court found no evidence of any document providing for an express trust. First of all, the court would like to define express trust. He said, I got to educate this motherfucker. And I understand why you got to educate these ignorant motherfuckers, man. These ignorant niggas. First of all, the court would like to define express trust because they love that word express trust. They don't know what it means. Because there seems to be a misunderstanding as to exactly what an express trust is. Seems to be. Since we are talking initially of a trustee, which respondent says that is a term that is foreign to the Moorish Science Temple of America. That's why they started off the case showing all of the Moorish Science Temple of America's documents, how they were incorporated. It's even going to show the Noble Drew Ali intentionally crossed out the word trustee in his paperwork. He crossed it out. Let me show you. They're going to talk about it. Since we are talking initially of a trustee, which respondent says that is a term that is foreign to the more signed simple of America, a trustee would have to be duly appointed or designated, and that term includes a person with whom or in whose name a contract is made for the benefit of another. But the bottom line is there's absolutely no indication that the founder of this movement ever intended a trust of anything. The judge determined that not only was the word trustee not used in any of the temple's corporate documents received into evidence, but that whoever drew the temple's articles of incorporations up expressly eliminated, crossed out the word trustee in the form document and replaced it in handwriting with the word check. How do you get over this? But they claiming they got a trust. And the only reason they think this, because don't none of them know trust. It's easy to fool people when you don't know nothing about the subject. More Science Temple of America got infiltrated. I have no doubt. That had been being said for a long time. But after I read this and see how he got down, I think this is the point it got infiltrated. Because once they splintered everything up like that, that's why they disseminating all this weird shit that y'all hearing and everything. A lot of stuff is not coming directly from the Moore Science Temple of America. It's not. They're not doing all this. They're not trying to do any of these processes or anything these people are doing. They walking around, calling themselves Moors with fezzes on their head and not formally recognized by the Moore Science Temple of America. That's why you don't never hear them talking about the Crown Circle 7. All they walk around with is talking about have you claim your nationality and trying to get you to buy some shit. They doing business on our land. You know that shit never sounded right. I'm like, when they say that shit to me, I say, man, you know they took this shit. Every time they say that shit to me, I think about Debo and Friday, about when he came to get his bike back. You know, he let Debo use the bike. And he came back, Debo, man, and give him the bike. But I gave you the bike. Oh, yeah, homie. Bop! That's my bike, punk! That's the United States. If it's your land, how you going to get it back? I'm going to go off on the Washita next too. You're not exempt. I got you too. We're going to go over two cases. The heirs of Henry Turner, 1848, because y'all walking around. Y'all did win that case, but what you're not telling everybody is how you lost it. It got overturned in 1850. We're going to go over that too. I've seen all of that. Whoever that queen was, I don't want to disrespect her, but it's just something about a group of men following a woman that just doesn't sit right with me, but hell, they want to do it. But they brought me all her paperwork. What she did was she did an administrative process, like a UCC process, and put them in default. And from that, she said, it's our land. Now, I will say one thing about the Washita. They gave the Washita an opening. They told them, this is what I read. This is not what I heard. This is what I read. If they can prove that they had title to the land prior to the Louisiana Constitution, they would honor their claim. It's too much stupidity going on, man. These dudes don't read. Y'all following a lot of people who are not very astute. They are not, first of all, they don't know grammar. These are the niggas that was in high school fucking around smoking weed and shit. Now they want to be intellectuals and all this shit. Law take time to learn. Attorneys go to law school for 3 years. Let me read this again. The judge determined that not only was the word trustee not used in any of the temple's corporate documents received into evidence, but that whoever drew the temple's articles of incorporation up expressly eliminated, crossed out the word trustee in the form document and replaced it in handwriting. We all know in a contract, anything written by hand supersedes anything typed. In handwriting, the word check. He had no intention of forming a trust. Where are they talking about the Moorish trust? This is the argument I got with them. This is not my first time doing this, y'all. I did this 10 years ago and took the video down because it was causing a lot of tension between me and the Moor. But I don't give a fuck because I don't have nothing. I don't have no problem with the Moorish Science at the Temple of America. This is not an issue with them. This is an issue with these little fringe niggas running around out here. They started their own shit. Having found no evidence of an express trust to support petitioner's claim to a secular leadership position of the property of the temple, the court ordered the permanent injunction restraining petitioner from referring to himself as an officer, director, agent, or trustee of the temple. He gonna fire back at him, though. Petitioner from referring to himself as an officer, agent, or trustee of the temple. Petitioner filed a direct appeal with the Court of Special Appeals on the 22nd of December, 1998. He ultimately asserted 3 grounds for the reversal. And this is why I think he had good counsel. This nigga, let me tell you something. This dude, this is what fucked me up about this. He seemed illiterate to me as far as trust. Crazy. But I don't know who he went to. He obviously got some counsel because this appeal, he got laser accurate. His appeal don't even match his original petition. So right here, he ultimately asserted 3 grounds for reversal. 1, the circuit court lacked the authority to resolve the religious dispute disputed by the case in light of the First Amendment of the United States Constitution. And number 2, the requisite likelihood of irreparable damages to respondent to justify an injunction was not demonstrated. And number 3, the court in ordering the injunction failed to apply properly the term trustee, at least in the sense that term was understood by petitioner. On the 3rd of March, 2000, the Intermediate Appellate Court affirmed the Circuit Court's judgment, holding that the Circuit Court properly resolved the dispute by neutral secular principles, that trustee was not a term used by the temple, and that the temple had suffered and would continue to suffer irreparable harm from petitioner's misrepresentations. We granted certiorari on the 23rd of June, 2000, Bay versus the Moorish Temple, volume 359. This is in Maryland. Page 330, this is a Maryland Reporter. Pages 333, page 753, the appellate second edition, and page 1031, this all happened in the year 2000. Because we shall decide this case based on a point embedded in petitioner's 3rd question, we shall not answer his other queries. The Circuit Court possessed the authority to consider injunctive relief in a legal dispute involving a religious organization. Before we could consider whether the lower court properly concluded that respondent satisfied the requirements for the issuance of a permanent injunctive relief in this case, it is necessary first to address petitioner's concern that the trial court did not possess subject matter jurisdiction to hear this case. The parties agree that Maryland courts, like courts generally in this country, have no authority to resolve religious disputes. And they have a lot of Moors in Maryland, in that tri-state area. Matter of fact, when I started my high-frequency radio, that's where all the first people who started listening to me were from. They were from Maryland. Maryland courts have legitimate interests, however, in resolving secular disputes, including those involving property interests or those requiring an interpretation of corporate charters or bylaws through the application of neutral principles of law. The pith, I love this word, pith. I love this word, pith. Never pass a word you don't know the definition of. What does pith mean? concise, forcefully, containing much. Let's say, I didn't mean pithy. Let's take pith. Pith, the essence of something. All right, so the essence of petitioner's argument in this regard is that it was improper for the trial court to settle this ecclesiastical dispute because it does not concern real or personal church property, but rather the rightful leadership of the temple. In numerous pleadings and papers filed in the circuit court, however, petitioner repeatedly asserted that all trust property, assets, and records should be placed in its immediate possession. Okay, that's where they got his ass. To this, we remind petitioner that when rights of property are involved, the courts of necessity must proceed to consider and adjudicate those rights, not only to solve the particular case and the rights of the litigants before them, but also to preserve definiteness and order in the holdings of property by religious corporations. We therefore conclude incongruous for petitioner to argue that the dispute does not concern real or personal temple property when he put the ownership or right to possession of such property at issue. All right, well, you can't say that, bro. You the one brought it up. Talking about, you can't. All right, so they didn't use that. Petitioner also asserts that the Court of Special Appeals erred in resting its resolution of his subject matter jurisdictional challenge on the temple's alleged proprietary interest in protecting its good name as a stable religious organization with an orderly mode of government and succession of leaders. Because the trial court's jurisdiction over his dispute stemmed from other proprietary interests, as we've noted supra, which means above, we find it unnecessary to reach this issue. Standard of review. He's going to talk about injunctions. All right, and I'm not going to go into all of that. Y'all can read that later if you want. The circuit court erred in granting a permanent injunction. I'm going to go down here. Right here at trial at present, Lovell, on behalf of the respondent, testified that while petitioner was holding himself out as a trustee of the temple, petitioner was not soliciting any money under the guise of that alleged trusteeship. Moreover, when asked whether petitioner's conduct had caused any dissension within the temple, Lovell responded, our organization is a national organization with over 360 some temples around the country. This man is not even known by most of the people that's in our organization. Rather than demonstrating irreparable harm, such as evidence supports the conclusion that petitioner's conduct did not predict future irreparable harm. In other words, to grant a petitioner, it's a judgment of the court, appeals reversed, case remanded. Now, why was it remanded? Because the Morris Science Temple could not demonstrate that, that he was injuring them by his activity. But he's going to go back and make it everybody seem like he won. There really is a trust, and he won. All right? Yes, can I help you?
This is T. I just had to tell you this real quick. My client won his case.
Your client won his case?
They came back not guilty. Yes.
Wait a minute, say that again so everybody can hear. Your client what?
Won his case.
Came back what, not guilty?
The jury came back not guilty. He decided to fight. I was in court last week with him. But yes.
Is this the dude with the dope charge?
Trying to cry. Yes.
And he won?
He won.
That's good. That's good.
He won his case, but his other two co-defendants, they came in guilty. But that's why I told him to settle, because I knew that he would have won. But yes, he won his case. And let me tell you what Georgia did.
Didn't they hold him in jail for 2 years?
30 months that boy has been.
He finna get paid. He got supposed to get paid too.
Yep.
You got to get paid too. Y'all need to work together on getting that lawsuit. Hey, look, I'm doing a live right now. Just go on YouTube.
We got another person. So when they talking about people don't stand on their square that don't win, yes, they do. Because they didn't have a case. And he decided to fight. So, yes.
That's great. That's great. Hey, look, I'm doing a live right now. Go to YouTube. I'm on, and we'll talk about it later, and we'll celebrate that. But congratulations on that win.
Okay. All right. Thank you. Bye.
All right. She just won. She's been working with clients. That's tomorrow. She won her case, and she has a lawsuit against the government for holding her in jail for 2 years, and it got overturned. And we just got another gentleman. They've been holding him in jail for 30 months. He just won his case. He's going to us automatically getting paid. They holding you in jail for 30 days. That's a lawsuit. For 30 months. That's millions of dollars of lawsuit. That's what we're doing over here. The grant, to grant a permanent injunction, there must be evidence adduced that the party seeking the injunction will suffer irreparable harm without its issuance. In this case, respondent failed to present evidence that would suffer irreparable harm as a result of petitioner's conduct. As legally ephemeral as petitioner's claims to leadership or trusteeship of the temple and its assets may be on this record, we can find no evidentiary support to justify the issuance of the injunction. That's all this was about. Okay, now let's see what this dude went and told everybody. Okay, put a 1 in the chat if you still roll. And I'm gonna put this link in the chat. Y'all can pull it up and read it yourself. Y'all see this dumb nigga in the chat talking about Minnesota Rule of Practice 220? Why are you telling me I don't? Do you know that we are the ones who brought you the information? He said, teacher, you're still confused. No, I'm not confused. You're a stupid motherfucker, okay? You're stupid, man. That's all I can say to you. Thank you for the $5, but you're stupid. You're ignorant. And I'm telling you you're ignorant. Go make a video, and you make a video, I'm going to destroy you. Do you understand? Do you understand? I'm not going to rest till I chop you to a million this Holly Park 3273. I'm going to destroy you. I'm going to decapitate you. I'm going to cut your nuts off and feed them to you. You fucking with the wrong nigga. I'm going to cut your nuts off. Y'all, these niggas dumb. They be talking to gangsters and shit. Don't know who the fuck they talking to. Motherfuckers are stupid. They say, he's like, let's look at what he said. All right. 1993 Legislative Journal pay. Okay, right here. We get into this. Moors, blacks, and African Americans, real economic empowerment through the Express Trust being permanently presented. Islam, may this notice greet all you well and wakeful, for the wakeful die no, whereas those who are heedless are is dead already. If you are not aware, this notice is to make you aware of the said trust existence, its benefits to you, and to invite you to participate in its performance. As Moorish American blacks or African Americans are the primary beneficiary of the extremely extensive fee simple estate conveyed to us in an express trust that was duly created in 1928 by the trustor Noble Drew Ali for our economical, political, and social redemption and regeneration. The said trust was duly created in conjunction with the statute of frauds and perjuries and the parole evidence rule. Parole means oral. Okay, I don't know what the fuck all of that means. How does that apply to anything with the creation of a trust? This nigga is just throwing out words, and his followers somehow, some kind of way, have rationalized this shit to me. Like this dumbass nigga in the chat about Minnesota Rule of Practice 220. He don't know no grammar. This is what they talk about, y'all, on 220. He say, I don't know what I'm talking about. These illiterate ass niggas. All right, let me go over here. All right, so right here, this Minnesota Rule of Practice 220. Let me read this to you. Remember, they made a video on me saying I don't know how to read. The Register of Titles is authorized to receive for registration of memorials upon the outstanding certificate of title an official birth certificate pertaining to a registered owner's name in said certificate of title showing the date of birth of said registered owner, providing there is attached to said birth certificate an affidavit of an affiant who states that he or she is familiar with the facts recited, stating that the party named in said birth certificate is the same party as one of the owners named in said certificate of title, and that thereafter the Register of Titles shall treat said registered owner as having attained the age of majority at 18 years and that the date of the birth shown by said certificate. Now, the nigga in the chat, this is an ignorant nigga. They read this shit, they don't know what they reading. Let me show you what I'm talking about. They ignorant. Y'all, these niggas is ignorant and dangerously ignorant. Dangerously ignorant. Let me show you this. Now, first and foremost, this ignorant nigga in the chat, he don't know what a fucking rule of practice is. It's dumb nigga shit. He don't know what a rule of practice is. He said, I'm confused. This is how they be insulting me. This nigga don't even know grammar. He said, I'm confused. Okay, I'm confused. A trust cannot stop they keep asking, a trust cannot stop a foreclosure. Why is you ignorant niggas keep saying this shit? You can't not transfer a title you don't have. They think putting in a trust does something magical. A trust does not stop. Put the shit in Chat GPT, nigga. Stop asking me. Y'all been saying this shit for 15. I've been telling y'all a trust cannot stop a foreclosure ever since 2010. And just like this birth certificate authentication, I can't do nothing with it. But let me show you something. These ignorant niggas. These niggas is ignorant. Ignorant niggas. Here's the Minnesota rule. Now I want y'all to see this. These are general rules of practice, not rules of court, not a rule of law. They don't know that though. They ain't gonna look it up. You got to get a Black's Law 4th edition to find the definition of the general rule, what a rule of practice is. So you go down here. Here's 220. It's in Part C. There's a Part B, and there's a Part A, and this shit is dealing with registration of land titles. We're talking about real estate. And I'll give you the synopsis, all right? You got the Uniform Transfer to Minors Act. This is what this led me to. When you put real estate in the name of a minor, they're too young to contract. It's an executory contract that can't be executed till they reach the age of majority. In some states, it's 18. In other states, it's 21. Once they reach the age of majority, to transfer that real estate into their name, they have to come to court, and you have to bring your birth certificate. You cannot bring the birth certificate just free from vital statistics. You have to have it authenticated, because every evidence that you put into court has to be attested to under penalty of perjury. Where did I get that from? The rule of evidence of vital statistics. They have it in Minnesota. I did a video and showed you all this shit. Next, you have to have an affidavit from the custodian, because the property is put in the name of a custodian of the property. And you got to get an affidavit from him attesting that this is the same person that's on the birth certificate that is also listed on the real estate. These is ignorant niggas.